Caparo Industries bought some shares in Fidelity PLC. They thought this was a good investment because when they looked at Fidelity's accounts, which had been prepared by Mr. Dickman, they saw the company made $1.3 million before tax. They completely trusted Mr. Dickman's report and didn't bother doing their own assessment, even though they actually never met Mr. Dickman. After they bought the shares, they found out that the report was wrong and Fidelity had made a loss of over $400,000, so it wasn't a good deal after all. Since they now owned part of Fidelity, they were not going to sue themselves, so they decided to sue the accountant, Mr. Dickman. However, the court ruled that Mr. Dickman did not owe Caparo a duty of care. This case sets out that someone owes a duty of care when 1. There is reasonable foresight of harm, 2. There is sufficient proximity between the claimant and the defendant, and 3. It is fair, just, and reasonable to impose a duty. In this case, the court decided that since the accountant knew nothing about Caparo and did not know that Caparo was going to rely on his report to make a decision, there was not sufficient proximity between Caparo and Dickman, so there was no duty of care and therefore no liability in negligence.